next case to come before the court is Schmitt versus Ward. And each side will have 15 minutes, and the appellant may reserve up to 5 minutes. And just let me know if you want to save some time, please.
Thank you. It pleases court and counsel. My name is Frank Simino. I'm here on behalf of Mr. Ward. I would appreciate having 5 minutes reserved.
That's fine. Thank you, sir.
Included in this. It pleases court. There is a history associated with this case, and this matter has been before the court on a number of occasions. I think the first concern that I have with what's occurred at the most recent decision of April the 17th, 2015, is that, again, the trial court has not determined marital versus separate property. I believe that that was the issues that were brought to this court in the very first appeal, in the third appeal, and in the fourth appeal. All of those issues were addressed by this court, indicating that that issue had not been resolved. To date, it still has not been resolved by the trial court. And our concern is obviously that relates to the property settlement, as to how the assets are divided between the parties, in light of the fact that there are two properties in particular. One is Ranch Road, 1024 Ranch Road, which is a 2-unit building with 4 apartments in each one. And the second one was Scupper Road, although I would acknowledge that there is some statement in the prior testimony that Scupper Road has been sold and that there has been a proceeding of dividing of those in some fashion. My only concern being, Your Honor, in relation to those is that I believe those are both properties that existed prior to the marriage, and that this court has definitely indicated that those should be identified as separate property, not marital property. And again, I think that relates to how the property settlement moves forward. At the present time, Judge Hoffman's decision of April the 17th, 2015 indicates that there's a $2,000 some odd amount that is to be paid by Mr. Ward to Mrs. Schmitt. If those properties are not included as marital properties, in fact, that's something that will be modified. Secondly, I think that the court in its April 17th order further indicates that if this mortgage is not lifted from the 1024 Ranch Road property, then there is going to be a sale or an auction of that property. If that's a separate property, non-marital property, I don't believe the court has authority to do that.
Let me ask you a question. Are the deeds to these properties in the name of the LLCs?
Your Honor, the LLC was the owner of these properties prior to...
My question is, are the deeds to the properties in the names of the LLCs?
Yes, Your Honor.
Both properties?
Yes.
And the LLCs have members to them?
There are members.
And were either of the parties or both of the parties members of the LLCs?
Mr. Ward, on January the 1st, 2005, was the sole member of the LLC, Ranch Road Superior Properties LLC. He was the sole member of that partnership that was the owner of the 1024 Ranch Road real estate.
So how did Ms. Schmitt get on the mortgage?
I believe she signed the mortgage on it. I mean, she did it.
And she's not a member?
She is not. That was, I'm giving you I believe the properties were bought in November, that property was bought in November 4th, 2004. And on January the 1st, 2015, that limited liability company corporation was in existence, and the sole partner in that was Mr. Shaine Ward.
And as the sole member in that LLC, would he have authority to acquiesce to the sale of that property?
Would he have the authority to do that? Well, I believe as the owner, yes.
And did he not do that at a hearing or a status conference on May 1st, 2014? Did he not say, yes, we will sell this property if I can't refinance it?
I don't think he ever agreed to that in the transcript, Your Honor. Okay? And I guess what I would also indicate to the court is the August 12th, 2014 journal entry that supposedly is the memorialization of those hearings was never executed by his attorney at that time. I think we brought to the court's attention that where the signature appears for Mr. Shaine, all it says is seen no response. And that then, I guess, would raise a question in me as to whether or not that was an agreed entry.
Well, that would be on the transcript.
I guess my concern, Your Honor, would be the concern, I believe the transcript also would support that the majority of the discussion dealt with Scupper Lane. There was definitely an agreement, I don't disagree with that Scupper Lane was agreed to be on the record to be divided. I don't believe there was any issue about selling the property as far as 1024 Ranch Road.
So as far as 1024 Ranch Road goes, you're stating that your client owns the majority of the LLC that has the deed to the property.
Yeah, I believe there have been some transactions on it since.
But his ex-wife's on the mortgage.
Correct.
So what, and he hasn't been paying the mortgage.
Correct.
So what is your client proposing here?
In relation to that property?
Yeah, what do you see going to happen here?
Well, there's another lawsuit, Your Honor, that is
Yeah, because
involved.
it's in foreclosure now.
Well, it's not foreclosure. They chose not to go into foreclosure. They just went for a money damage, or money award. And there is no foreclosure
So
on it.
how does your client see this going forward?
Well, we have been discussing alternatives as far as trying to put that property back together.
Well, how do you get the ex-wife off of the mortgage?
Well, it would have to be a refinance.
I mean, he's been ordered twice to do that.
Well, there's been a lot of challenges during the course of this proceeding. The only, I guess, there's an effort made at trying to address that, Your Honor. The only other thing I would say was, I believe that as far as the Ranch Road, I think another problem that I have with it is under my second argument, Simon Rear, I don't believe that LLC was ever made a party to the action, and so I think that the court, when Ms. Grasky raises the issue of lis pendens, I don't believe that the raise has ever been a part of the lawsuit in this matter.
Well, why would
Never
his
served.
membership be the property?
Pardon?
Why wouldn't his membership in the LLC be the property that we're talking about? He could say, I'm going to make her be the sole member and give her that, because
And
the membership.
I appreciate that argument. I would indicate to the court that I feel as if a member, but the other side of the coin is that on January the 1st of 2005, 7 months prior to the marriage, that was solely in his name under the 1024 Ranch Road Superior Properties LLC. So it had nothing to do with her in relation to the ownership, and it's clearly a separate property.
But has he commingled it now that the mortgage is in her name?
I don't believe that would be the case, Your Honor. I would argue against that. I don't believe there was a commingling of it. The assets that went into that, for the background, he borrowed $45,000 on another property that had to put that down as a down payment. Every payment that came for that property came out of the account that was associated with 1024 Ranch Road. So there were no marital assets that were ever put into this property to move it forward. So I would argue that that's not the case in this matter. This third argument that I bring before the court would deal with the failure of the trial court to have a child support worksheet attached to the entry, and I believe that that is in violation of the Summit County Rules of Domestic Relations. I don't believe that is attached. The last argument that I would present to the court, Your Honor, would relate to the fact that there was requests for an in-camera interview of the child. There was one back in May of 2014 that I acknowledge was withdrawn. However, in the oral hearing that occurred on December the 2nd, there was a specific discussion between the court, Judge Hoffman, and my client, where he was specifically requested that there be an in-camera interview of the child. The judge, during the course of that interview, goes from pages 109 of the transcript of December the 2nd through pages 113 of that transcript. And during the course of that discussion, there are specific acknowledgments that he's made the request. The judge has indicated he'll take that under advisement. He's indicated that he would, I guess in a way, think about doing that. But I don't believe that that's the option that he has. I think the statutory requirements are that once it's requested by a party, the word is used as shall conduct the interview.
Wasn't the second request made after the parties agreed to an allocation of parental rights and responsibilities?
Your Honor, I believe that December 2nd was a discussion, December 2nd, 2014. I believe there is no agreement that I could find that really related to that. as far as being on the record. It's a discussion that was going on in open court regarding this issue, parental rights and responsibilities. And I think that subsequent to that oral request, on March the 2nd of 2015, Mr. Shaine Ward filed a written motion for that. A couple of days later, on March the 19th, 2015, he filed a motion for the reallocation of parental rights and responsibilities. So those motions were all pending before the court prior to the decision of April the 17th, 2015. And
Counsel, you're in your rebuttal time too, if you'd like to say that.
Your Honor, that's fine. Thank you.
May it please the court. My name is Leslie Gransky. I'm here on behalf of Melissa Schmitt, the appellee in this matter. This court has had additional dealings with Mr. Ward that aren't related to the domestic relations. Most recently, when Mr. Ward, as is in this record, obtained welfare health insurance for this child when wife was providing health insurance for him, didn't tell her, then used those benefits to get medical care without mom's involvement and to make histories that had none of mom's involvement and to use that to interfere with the child's IEP. During that time, we only learned that he had gotten the welfare health benefits when the Department of Job and Family Services contacted mom and said, "Why don't you have insurance? You're employed." And she said, "I do." And then we learned that dad had claimed this child as his, that he had custody, that he had obtained the insurance misrepresenting his income, and Ohio Department of Job and Family Services went after him for reimbursement of the benefits he had gotten through his deceit. And he went to a hearing, and as he does all the time, he agreed to a resolution. He said, "Yes, I did that bad thing, and here's my check. Don't punish me." And then as soon as that was resolved, he filed an administrative appeal to the General Division, and when he lost there, he filed an appeal here, and this court looked at all these facts. And it is just that context. If you look at how he has behaved and the cavalier and disrespectful treatment he has had for our court system. Now let's have a look at this one. He's claiming that the court didn't designate property as marital or separate. And yes, the statute says the court's to do that. But if parties reach a separation agreement, the court doesn't have to do that, and there's no necessity for a finding, or else you're going to have hundreds of thousands of divorces that aren't divorces because they've reached a separation agreement and didn't make that finding. Shaine Ward entered into an agreement. It's clear in the record. It was set forth in that August 12 entry. It was submitted to his counsel in June, but because Shaine Ward, of course, had ceased to be willing to live up to his word, it made an open court, he wouldn't let his attorney sign it. So pursuant to Local Rule 28, when counsel could not sign it, it was marked as seen but not approved. I obtained a copy of the transcript of the hearing at Ms. Schmitt's expense so that the court could look at the transcript and look at the proposed order, and the court approved the order. You know why? Because it reflected the agreement that was made in court. If you look into this record, it gets even worse because Mr. Ward is claiming that Judge Hoffman, his attorney Larry Shenize, Leslie Grasky, and Joni Burka, the court reporter, all colluded and got together and put together a different set of agreements.
Your Honor, I apologize.
It's in the record.
I guess my concern is...
Well, sir,
Thank you.
I'm sorry, I just want you to understand the rules. We don't object here, you'll have a rebuttal time. Okay.
But his allegations are in that record. That's the context here.
Counsel, can I,
Certainly.
before I lose track of this,
Yes.
back you up to the final appealable order issue? Because I want to make sure we get to that.
Thank you. I have concerns about whether this is a final appealable order, which will hurt my client still further, because now Shaine Ward has played another game with this court system and has gotten an appeal going, taken a whole year. Next week is the 17th, and she's gotten no relief, and she's got a $250,000 debt hanging over her head in general division, because the court said, I'll auction it.
Well, okay, but that doesn't go to whether or not it's a final appealable order and your concerns regarding that.
My concerns regarding that are the order for the sale of the property doesn't deal with everything. And this court has recognized that an order to be final has to deal with all of the issues.
What doesn't it deal with?
It doesn't deal with what happens to the proceeds. It doesn't even say you use that to pay the underlying debt. And, you know, that's a fairly significant issue. Nothing would make me happier, actually, than for this court to say it's final and appealable, but I felt it was my duty to raise the potential issue so that it could be considered carefully.
So it doesn't dispose of the proceeds of the sale of the auction of the Ranch Road property if in fact that happens?
Correct.
Okay. Is there anything else that you maintain that it's missing with respect to the finality issue?
That's the core of the
That's the core of
finality issue.
it.
Thank you. And Mr. Ward then tried to play with the Ranch Road property by attempting to change title owners. Okay, so this is very significant. Mrs. Ward at the time was liable on this incredibly large debt. Okay, she had been involved in the LLC, but of course he took her off that before the hearing and before it was made final. But the property was clearly described, Revised Code Section 3105-171 (b) says the court has jurisdiction to divide marital and separate property. So to the extent this is his separate property, the court maintained jurisdiction. It also had jurisdiction over a debt which was owed by both of the parties before it. That could be separate property debt of both of them, but the court had jurisdiction over it pursuant to the statute. Mr. Ward continued his shenanigans by transferring the title to the LLCs, transferring the LLCs, receiving no compensation for giving up 95% interest, he says, in the LLC. Anyone who has taken...
What's the difference between the court ordering Mr. Ward to sell a piece of property and ordering the LLC to sell a piece of property? Because it's not titled in Mr. Ward's name at the time the order comes down, correct?
Correct. The jurisdiction that the court has in this matter, pursuant to the statute, is over the thing, the property. It was properly described in the initial pleadings. The court assumed jurisdiction. There's no appeal of that, of the court taking jurisdiction, whether it says marital or separate property, which is what the statute says at Section B, that the court can divide marital and separate property.
Again, isn't the property that the parties have a membership in an LLC? They have an LLC, they don't have the property. The LLC owns the property. They have an interest in the LLC, but they don't in fact own the property.
That's correct, but the property is part of the
LLC.
So
the
the
memberships
court can, yes.
of the LLC are what the court has jurisdiction over.
Correct, but because it had jurisdiction over the LLC and the property was described in the complaint, the court had jurisdiction over all of the assets. It's like saying that I have stock in IBM and I own 70% of it, but we can't deal with any of IBM's assets because I only own stock.
But, okay, I understand that you may classify it as separate property and you may say the court has jurisdiction over separate property. But as a practical matter, because the LLC is not a party, does the court have the authority to sell property that is owned by real estate that is owned by a non-party? I understand your argument.
Sure. Because the LLC is not like a corporation, it is a group of people. The people were before the court, so the court had jurisdiction over the members.
So your argument is he's wearing two hats in the divorce proceedings, one as a party to the marriage and one as an LLC member.
Correct.
Okay.
And then he tried to play with that by transferring title, but the real estate itself, which was owned through the LLC, was subject to the court's jurisdiction from the beginning. Notice was served, a process was served, and that puts everyone on notice. So if he's tried to give this to someone to thwart the court's jurisdiction, and frankly to settle his ex-wife with a $250,000 debt while he keeps the property, Liz Pendant should prohibit that. I'd like to direct the court to assignment of error 3 on the child support worksheet. This is such a horrible case to be trying to do with details, but Mr. Ward invites error and agrees to things, and then he says, ha ha, you can't hold me to that. He owed 4 or 5 years worth of child support when, through negotiation, Ms. Schmitt agreed to take $200 a month in child support from an MBA who isn't working because his full-time employment is playing the court system and tormenting his ex-wife.
Counsel, I understand that this is a very emotional
I
type of thing, but we just.
I will
need-
withdraw that.
We just need to keep to, because we really can't consider that anyway.
Certainly. He has an MBA. He's got a $200 a month child support obligation, which, by the way, he has not paid, and we asked the court to remand, and this court said, you can enforce a child support order. We haven't pressed that because this issue is before the court. But she gave up years of child support in exchange for $200 a month. And that is why there is no worksheet, because there were extraneous issues. If we're going back, I guess the good news would be that we could seek the years and years and years of child support that he owes. As to the shared parenting plan, again, the parties reach an agreement on the record. We obtain a transcript. And then after that hearing is over, he's coming up with new requests. And the court properly ignored those because you should have done that before the hearing started. If you wanted to have a hearing on this matter, he should have had a hearing on this matter. And then we would have a transcript like this, and we would be looking at the manifest weight, and that would actually be somewhat easier for Ms. Schmitt. However, the hope was that if you actually reached an agreement with counsel, he had counsel, that the parties would be sufficiently satisfied with the agreement that we could move forward and let this little boy have a childhood. I want to go back, I'm sorry, I had missed a note on the commingling issue. You have this piece of property, and we have to go many transcripts back to the decree. And there had been marital effort put into that property, which further enhanced the court's jurisdiction to deal with this property. And I believe that this court should affirm the parties' agreement, which was reached with advice of counsel on the record, and give the court a chance to enforce the allocation of the Ranch Road property while we're also dealing with the lawsuit. Thank you.
In summary, as far as some of the things I was concerned about having been said, I don't believe they relate at all to the issues before the court today. And I'm concerned about the aspect that I think that there's two perhaps people here in this divorce who are concerned about the child. They look at it from their perspective as to what they think is in the best interest. In reality, it was Mr. Ward who got the IEP established because he was the one who pursued that and got them to establish that for the child. So that's all I want to say on that. In relation to these issues on the, obviously, I'm concerned about the in-camera inspection or interview. I believe that that's something that should have been done. I think during that December 2nd hearing, 2014, Ms. Grasky indicates that there's a proposal or there's agreements on the shared parenting plan. On page number 111 of December the 2nd, 2014, the court, the plans and proposals, there was not an agreement on the shared parenting plans. There were submissions, and the court said, so that we're clear on the record, pursuant to the demand, I'm looking at the parental rights. So that's December the 2nd, 2014, the court acknowledging that there was no plan. There were submissions, but there were not plans that had been entered into by the parties. Each one had their own.
But doesn't the court have the authority to select one of those plans or some hybrid of those plans?
My only concern, Your Honor, was Ms. Gradsky was indicating that there was a consent by Mr. Ward to the plan that I assume that she was referring to of her own, but there was not. There were two different plans that they did not come to an agreement, and the court recognized that during the course of that hearing on December the 2nd. Additionally, I wanted to point out to the court that at the same time, during that hearing, December 2nd, Mr. Ward from the stand apparently, a motion for in-camera interview with the minor child is still on play, I believe. And the court goes, okay, the court will take that matter under advisement.
I'm sorry, when was that? Was that the same
December 2nd on page 109.
109.
Yeah. And then the last, there's another request by Mr. Brown, his counsel, and the counsel at the end on page 112 says, if you would just have an in-camera interview with the child, Ms. Gradsky interposes saying the guardian doesn't want to put the child in the middle. I don't know if that puts a child in the middle, but the court then says, I will. So that's kind of the discussions or the hearings that were held on December the 2nd. In relation to this issue regarding the property, it is a muddled mess, but even the August 12th, 2014 entry does not talk about selling the property. If you look at the entry, there's nothing in there about auction. The only thing that it does talk about, it does say Scupper Road is resolved, and I believe the record is clear on that in the hearing. However, when it gets to paragraph 4, if Shaine Ward cannot complete refinancing, this court will conduct further hearing to determine the resolution of this issue. Now that's the August 12th, 2014 entry. When you get to the December, I'm sorry, I keep saying this. There was actually an entry of December the 31st, 2014 that is identical to the entry of April the 17th, 2015.
Isn't that entry, didn't we find that void?
You did.
Okay.
But I'm just saying identically on April this, that's why I just trying to explain my confusion. There was an entry on April the 17th, which is before this court now, and it's identical to the prior one. And at that one, the court does go beyond and indicate that they're going to put it for sale or auction. And that is something that I don't believe the court has authority to do, and I don't believe that there is the ability to do that as far as what the domestic relations court has the jurisdiction of. And I don't believe that they obtain the jurisdiction to do that.
Thank you, Counsel.
Thank you, Honor.
Thank you to both sides. The court will take the matter under advisement, and a written opinion will be prepared and sent to both sides as well as